This is not a regular bench, madam. Regular bench will come.
For judgment, item number 1, WA 3171/2024.
The appeal stands merit and the same is dismissed. No order is to cost. Do one thing. It is not like this. No, it is not like this. It should come equally here with I agree, not below. Okay? So I will just put a signature. Sign it. It will come equal.
Item number 2, WPC 9367/2025.
Will come like this. We do not find that the instant case warrants invocation of extraordinary powers conferred on Article 226. Writ petition fails, no order is to cause. Do it in this way. Huh?
We have filed challenging the no confidence, and the no confidence between has been fixed to 20%. And clearly, if it come tomorrow, we know there is no confidence.
You have a confidence now to be listed. No confidence you suffered. Now you have confidence.
No, because we have to pardon your lordship, my lord, two more habeas corpus matter. Habeas corpus matter, after death of his mother, the minor, after death of his mother, the minor child is considered by this family member of the opinion and not to illegally detained by the minor child. Lordship, 5 years minor child.
Mr. Lordship Commission, I have filed a CRLNC which was listed.
What is this? I don't know.
I have filed a
Criminal miscase.
CRLNC.
Criminal miscase.
Okay.
Criminal miscase. Yeah, and interim order was passed by Honorable
In this
Justice.
case means 482.
482. Yes. My lord, it was listed before Honorable Justice. My lord, that is true. An interim order was passed. It has expired. So it was once again listed before court number 8. And the court number 8 has directed to list it once again before court number 15. And I have mentioned it before court number 15 and
See to it. We have already done. Don't give a slip. Not required. I am aware yesterday the file was placed. Don't worry.
Yes.
Item 8, my lord. Item 8, I have some personal problem, medical problem, and can take no after this. Item 8, medical problem, I have both medical some.
my lord.
Item 8.
Inform the other side, that's all.
No, government is just government is the other side. There is no private other. There is no interim order.
Yes. Put it after petition.
Lordship, these are fresh admission matters. Twice before this court, but could not be taken up, and next day it is still not.
Our incompetence, what can be done?
Lordship, kindly take up the
Please,
matter before
please,
petition.
please pass on the memo.
Priyanki permitted to file written submission in the back where the challenge to access.
File it.
My lord, kindly allow it.
Record an order that written submission is filed today.
Fresh admission matter.
I'm very pardon your lordship. Your lordship, this is not well. Item number 3 in the supplementary list.
Is that-
It's not adjournment.
Have you served copy on the other side?
Serve the copy.
Served copy.
So it will be taken up very soon. Just wait. Yes, call.
Item number 1.
11 candidates in the same list, securing lesser mark than the respondent number 1 have been selected and continuing in service. Therefore, your lordship, by order dated 13/8/2024, order number 6, paragraph 4,
The secretary OPSC will be obliged to produce before this court the chart based on the three.
Page?
My lord, the order sheet of this honorable court, order part, order number 6, dated 13/8/2024.
Yes.
Your worship, paragraph 4, next page.
Paragraph 4?
Of that order,
Okay.
the secretary OPSC
Hmm.
will oblige to produce before this court the chart based on the pre-revision and post-revision evaluation of answer sheet, taking into account the number of vacancy advertised category-wise for this court to appreciate as to whether in violation of Article 14 and 16 of the Constitution of India,
Yes,
as
yes.
much as
So lesser.
lesser meritorious candidates based on the recommendation of OPSC are working, while more meritorious candidates have been left out. Then I will take your lordship to another order passed by this honorable court. Order number 10, dated 4/9/2024. After much deliberation of the parties, the honorable court again in paragraph 4. In compliance of this court order 8/8/24, the OPSC has filed an affidavit considering the fact emerging from the affidavit which has been filed. We direct the chairman OPSC to convene a meeting of the commission and take a definite decision.
What is the outcome of that meeting? What is the outcome of that
My
meeting?
friend not addressed to your lordship. Yesterday he concluded, my learned friend has not addressed to your lordship. Considering there are 2 vacancies available.
No, no,
for the customers.
are you aware of the outcome of this order?
My learned friend can only say.
Oh, no, they must have disclosed subsequently by way of pleading. They must have.
There is a meeting. In that meeting, it has held that since 11, previously they have disclosed before this honorable court, 8 candidates securing lesser mark than the petitioner, they have been selected and appointed.
That is what they also argued yesterday also.
But
They indicated that
no,
these are the.
But it is found 11 candidates are continuing who have secured less mark.
No, what I understood from their argument was that their argument goes that when the initial select list was or merit list was published on the basis of the mark them, there are certain candidates who really came under the zone of consideration or appointment. So they were given an appointment. Then the writ petitions came to be filed, challenging the answer keys of some of the questions. So the appellant of their own suo motu, they constituted a expert committee to evaluate those answers. And the expert committee, they suggested that certain answers to the questions as suggested in the answer keys are wrong. So they said that this should be the correct one.
Right.
Then they readjusted it on the basis of that report and awarded marks to the all candidates uniformly, as I understood from their argument. And thereafter, obviously the marks which was allotted altered. The moment the alteration happened, there are certain candidates who really secured a position in the earlier merit list. They went out of the zone of appointment. And some who were kept outside the zone of appointment, actually they came within the zone of appointment. So they say that now this anomaly has arisen and they have to be adjusted or whatever. That is what their contention is. But those who have already been appointed on the basis of the first merit list, they say, how can we now throw them out?
Despite
If I correctly understood, that is your.
Despite the repeated direction of this honorable court, as against there was advertised vacancy.
Now, sir, I just try to squeeze the entire episode into a very small bracket. we have to just say things. Somebody who has really come within the zone,
My lord,
what would be their fate?
my lord,
What would be their fate? They have to find out the modalities. They have to find out the way out.
my lord,
That what they have to do it.
my lord,
Whether they can be adjusted.
my lord.
They say that there are certain vacancies which could not be filled up. Which could not be filled up because of the meritorious or eligible candidate having not found.
Within the prescribed 126 seats, even as per the revised merit list, we are coming.
So definitely that is what I understood.
Exercising that, this honorable court.
That is what we really wanted to understand. If you really come, then whether there is any possibility. There are two ways of looking at it, sir. I must be very clear so that you can assist me. You can assist me in arriving at a decision. There are two ways which I found. Maybe wrong. Please, if I'm wrong. There are two ways. If there is already an available vacancies,
Yes.
then the candidates who have really come within that particular zone of appointment, then they can be adjusted there. They should go there. Suppose if there is no vacancy, but they have come within the zone of appointment, then the candidates who went out of the zone of appointment, but actually appointed on the basis of one, their services should be, or their appointment should be cancelled immediately without hearing them or what to do.
The second part, absolutely, I have no complaint. Even if some candidates securing lesser mark than me, they should be removed.
Correct.
That is not my contention at all. And as per the direction of this honorable court, 2 seats have remained vacant for these respondents. And these 2 respondents have secured much more marks than the last candidate who have been appointed, according to them.
No, the difficulty is, again, I'm saying, the difficulty what arise in this case is that's big after the adjustment or alteration of the marks on the basis of that second export, then the last cutoff marks which comes, that really is above the marks which you obtained. If I correctly remember, 192 or 191, something.
Contrary to his own argument, because of the fact is this. My learned friend's argument is there is no fixed cutoff mark. Suppose 100
Can't be.
can be.
They cannot be. Somebody says that
If
they have to set a cutoff marks impossible and improbable.
They will produce the list of unreserved candidates.
I think they produced.
They have not produced.
No, they showed us the merit list.
But I'm
See,
the unreserved
24.
candidates who have selected and up to the last candidate who have been appointed,
First paragraph.
according to them, they are not producing that. They generally produce one merit list.
They have.
If
There is continuity of that. Thereafter, another next order. 26.
the list they have produced,
26.
30th.
No, 26. 26, 9.
There is no 26/9 order. Oh, I got it. It is not tagged, but I got it.
The earlier order.
if you are found
3 every
Senior officer.
procedure thereafter.
The list I had found yesterday containing the name of 171 candidates. The last candidate who has been appointed is Debashish Sahu. His name does not.
Ask for something if I correctly remember.
Debashish Sahu. His name does not contain within this 171.
What?
The last candidate who has secured the lowest mark but appointed.
No, probably, what they say is, Devassis, definitely after that particular second exercise having been undertaken by them,
My lord.
is really gone, he has gone out of the zone, part. He was within the zone when the first merit list was published
My lord, these
and the marks were disclosed. So, since he has already been appointed,
This honorable court specifically directed to them, please produce the merit list showing the name of your candidate and their marks, and from the your list who have been appointed and who have not been selected and appointed. If that list will be before your lordship
I
will.
think both the lists are there. One merit list is prepared on the basis of the examination, and the less merit list after that another expert committee was constituted, and then
That-
alteration has been done. These two lists must be there. I agree. So
They have not mentioned, they have simply filed the merit list and they have not mentioned out of these lists who have been selected and appointed.
They have.
No, your lordship.
They have hyperlinked. The certificate, which according to them,
That is in this
they say
171.
According to them, those have gone out of the zone, but since they were appointed on the basis of the first merit list.
Let my learned friend say from out of.
this.
No, my lord, I am asking. My learned friend has submitted an affidavit that 11 candidates securing less mark than the petitioner are continuing in service.
True.
Out of these 171, or my learned friend has said another 4. Another 4 they have. My lord, there is a.
There are these two lists.
Yes.
First list of this and the second list after. Then you will have to make a comparison.
Yes, yes, I need that. Let them say, this is the common list. Out of this common list, we have appointed these persons. Only this one. Then your lordship will be fair enough to say these persons, since they have appointed prior to the second exercise, their appointment may be said. I have no claim over that. Yes, they still till date they are hiding that list. Till date they are hiding that list. They are not producing.
Well, yeah, they are not hiding.
On 4 occasions,
No. This is the first list.
Both lists are before in that convenience compilation, both lists are.
you show us these up to this. It has been selected.
This is the convenience.
Yes.
So
Yes.
Please count.
My lord,
They have already disclosed.
my lord,
I think the page.
First one is at page 12, man.
page 12.
Page 12
Pre-revised list.
is a pre-revised list.
My lord,
They have already shown.
Page 12 has to be read
That's why I
with.
say Harish Das was the last candidate.
Thereafter, page 18, when 4 persons did not join, we gave another 4.
Correct.
There, that is where Debashish Sahu comes in. What my
Yes.
learned senior was talking about.
then where is the revised list?
No.
After the revision, this is pre-revised. My learned friend, this is the pre-revised. Yes, your lordship, may kindly have a glance.
No. This is the pre-revised list.
My lord,
He says that this was the list containing 171 candidates.
oblige,
Now they say that there are several categories.
oblige,
Unreserved, reserved, horizontal reservations.
right,
There are many things that.
right.
So they say that actually he stopped at Das under the UR category.
My lord,
Securing 189.558 marks.
my lord,
So they stopped. They exhausted the entire
right,
quota or
Right,
category.
right.
of the unreserved. Then what happened? Out of these persons,
my lord.
4 of them, I think 3 under the UR, they did not join.
5 you are not joined.
Four,
learned-
four
my
you are,
learned- my learned
four,
friend is-
Four you are.
four you are, one is.
I will point out,
I'm sorry.
I will point out
My
your lordship.
historical figure was wrong.
I have already pointed out.
Why? Not can you consider,
Well-
have the clarity of the.
Sir,
thing.
sir.
So why, four you are category candidate, they did not show. Then naturally, the persons who's below. The last, the candidate who has been offered the appointment. Then they have to go.
My lord.
So they say at least 180, I can page 18,
18,
that these are the four persons
right.
according to the merit. This prepared or published pre-amended
Right.
or pre-altered. This Devasys Sahu came within the job.
My lord.
So he was offered the particular appointment to that post. No difficulty. That can be done. This is a very normal rule of service.
Right. Right, I quite agree with you, lordship.
No difficulty. And one candidate of the SC,
My lord.
he also did not join, so one candidate was adjusted from the merit list. Now, when he says Devashish, so Devashish's name, I understood what you are raising. Devashish's name must be there in this, which is the serial number, tell me, sir. Devashish Sahu, serial number
Serial number 4 at page 19.
9.
19, page 19.
No, in the list of 21 candidates, sure.
At page 12 in the first list, he is not there. He cannot be there.
So what you did? So he was not there.
He was not
This
there.
appointment was after the altered list.
No, my lords.
Or
This is this exercise of recommending 4 candidates happened between the two lists.
okay. So this 171 was the total number of posts was how much?
198 was the total. Now let us.
Oh,
if
so
we
you only say the person who can be appointed. So all
yes, all the persons in at page 12, they have a right of appointment.
yes. Okay. Then why 120 was shown?
Pragyamanti is you are female. In our case, we are confined to you are male.
Female.
Yes, ma'am.
So you have that horizontal.
Yes, ma'am.
You have done. And what is the other merit list? Because there are marks where.
Yes, ma'am. So after the list was changed, page
No.
number 31 happens.
Before the list was changed.
Yes.
The marks obtained by this Loknath, Mona Lisa.
Yes.
Photo and the Devashi.
That is at page 19.
Oh,
So Haripada Das had secured 189.558.
I got.
The next person was Devashish Sahu, 187. That becomes the
This
new.
is before the altered list.
Before the alter. So we can say that the cutoff marks of the pre-revised list were again
Goes down.
went down.
87.934.
Yes, my lords. And at this juncture, the respondents had secured 184.2 and 187.002. So just
So they were below.
they were still below.
And then after the altered list,
Then when the altered list came, that is at page 31.
yes.
Just to point out, my lords, serial number 1 at page 31 is also at serial number 1 of page 12. Serial number 2, Asit Kumar Mishra, he was at serial number 5 in the old list. So he came up. Yes, my lords. Some people went down.
True.
Only one question, your lordship, put my learned friend. Devashish Sahu at the last, your lordship, my friend pointed out. In this list, whether the name of Devashish Sahu is mentioned. Revised.
He's not there.
No.
In the revised list.
No, sorry. That will not come. That he has admitted. This.
His position will be mentioned.
No, is.
Your lordship, they have mentioned the name of.
Let me take out the key.
Well,
And make a things more clear. When the first list was there, what they committed a mistake, they should not have committed. That they have simply published the candidates who come in the zone of appointment only. And did not publish the details of the other candidates
who are there is a waiting list, they should show it. They did not publish the waiting list.
Shall I
That
interrupt?
to have been done.
Can I interrupt only?
Secondly, they should have published the whole list of the candidates. According to the marks, is this secured? And then the persons according to the vacancy position shall be appointed in signature. They did not do it.
They have done it. I am submitting mine. After the written test examination is over, they evaluated the answer script. Their own pleading. They issued call letter to 193 candidates for verification of their documents. 193 candidates, including the respondents, they have admitted in paragraph 193 candidates. These candidates, please come. There are about 1050 candidates who have participated. About 193 candidates, they called the candidates for verification of the record, including the respondents. Thereafter, what happened, God knows, they selected only 171 candidates without publishing. As per their own rules, they have to publish in their website, this is the key answer. But they forwarded the name of 171 candidates. Then we come before this honorable court. Then this honorable court, before the SAT rejected our application, we approached this honorable court. This honorable court directed, you publish the key answer and also mark secured by them. Then they published the key answer. After the key answer was published, it is found 15 questions are wrong. What?
No, sir.
15 questions are wrong. And thereafter, we made a representation to them. Only 6 representations were filed before the authority. 6 candidates filed their representation, basing on which the expert committee was constituted. When they did not consider our representation, we approached this honorable court. This honorable court, under Annexure 3, has specifically directed, since there are already appointments made 171, 175, in the light of the expert committee report, you consider the application of the writ petitioner and similarly situated who has made representations. Only this was the direction under Annexure 3. And they consider 6 applications only, not all the candidates. And informed us that only there is no change in the cutoff mark being 189.558. These candidates, we examined in the light of the expert committee report, there is no change of mark. That is Annexure 4 before your lordship. Before that, they had already issued the appointment letter to Debashish Sahu and others who had secured 187 mark, but they were appointed. Therefore, we filed a contempt petition before lordship. You kindly see, they are saying that cutoff mark is 189.558. They have given appointment to 187.883. That is clearly wrong. Then in contempt, this honorable court directed, you have not applied to your mind to the expert committee. As per the direction of the honorable single judge, you carry out and publish the result. Then what they did, they examined again 6 candidates. Because let me take your lordship to the judgment of the honorable single judge.
They took into consideration only 6 candidates.
Only 6 candidates. The direction was that only, not to reopen the Pandora box, because they cannot control the proceeding.
That's true.
They cannot control the proceeding.
What else?
They found 192.01 one candidate, 191.1 some candidate. Our case is, since you have fixed the cutoff rate, cutoff mark 187, and according to that, you have given appointment to about 80 candidates, 71 plus 4. 75, 175 candidate, you consider our answer script in the light of the expert committee report.
They considered it.
They consider it and found
And the marks was 192 point something.
7, which is what they say. No, my lord,
No, sir.
Your lordship,
There is a catch.
only one,
There is a
only
catch.
1 minute.
There is a catch.
I will hear your lordship.
188 marks, it was a cut-off mark, this there is score, was in relation to an unamended merit list.
Your lordship, page 95 of the brief.
It went down to
For a minute.
7 point something.
For a minute, my lord.
4 candidates having not.
For a minute, I will draw your lordship's kind attention. I can properly assist.
Won't anticipate that we have not understood or we are against you.
No. Perhaps I am taking your lordship time. Perhaps I am taking your lordship time today, day before.
It is still open. Yes. Don't interfere.
Therefore, I humbly.
We are just thinking in a different way.
My.
Find out whether those candidates are capable.
Yes, there are vacancies. In fact, OPSC has just received a requisition from government that there are 20 vacancies. That is there.
We were thinking in that way.
Right.
You wanted after the.
No. Because I want every fact must be stated correctly. There should be clarity in the facts. Whatever law, your lordship will decide law.
Yeah.
I may cite 1, 2 decision, my lord friend may cite 1, 2 decision. That is a different thing. But fact must be, there should be clarity.
Then, sir, one decision will come.
Oh, lordship. Then it is open to us.
In fact, my learned senior has produced a 13th of April. 13th April affidavit. There is a letter dated 12 to 2025 from the government to the OPSC. And there they have said that there are 73 UR posts available. Two responses.
And by virtue of the interim order passed by this honorable court, I have annexed as annexure A by 4. The 2 posts may remain vacant. And in the advertisement also they have mentioned that 2 shall not be filled up.
But he is correct in one sense, because there's a cut-off marks say you have to fix before you embark the entire exercise. Absolutely fundamentally wrong. The cut-off marks varies and depends upon the number of vacancy for which the advertisement was made. It cannot be fixed. There's an eligibility criteria which can be fixed. That any person securing 40% of marks in the examination will be considered for a next level of examination. I can understand that is
Your lordship is absolutely 100%.
Cannot be.
Your lordship is absolutely. Your lordship is 100% right. I don't put a question mark to it. But in the context,
Let us see if there is a vacancy, you are 73 or can be done.
Yes, sir.
Who have been really knocking the doors on the court from the day one.
In fact, well, 6 people came knocking, and one of them was granted appointment because she secured more than the new cutoff marks. So Dr. Suman Tripathi was the
two vacancy which is kept open or which is kept
Yes, ma'am.
because of the interim order.
Yes, ma'am. Yes.
We just write down that the date of the interim order. Then
Date of interim order is
what is
18/5/2023
in WPC number 24199 of 22. Yes.
On 13/4 I have filed this affidavit.
Cannot be filled up, is there.
Right.
Because if your lordship requires any judgment on what fell from your lordships on minimum qualifying marks and cutoff marks, I had found one. What fell exactly from your lordships? That's what they say. Here, in fact, my lords, they say that the word cutoff mark has been used by the Supreme Court in a very liberal manner to refer to both minimum qualifying and cutoff mark. I will not take much of your time, your lordship. I'll take straight away to paragraph 32. There are a lot of paragraphs which are relevant, but I'll just show you. Manjushri is regarding minimum qualifying. Now, if your lordship sees page 32, sorry, my lords, page 461, para 32. We find that this court has been regularly and routinely using the words cutoff marks to describe the minimum marks required to be secured in the qualifying examination for being eligible for admission, or to describe the minimum qualifying marks to be obtained in an entrance examination. As this court has routinely used the words cutoff mark to refer to eligibility marks or qualifying marks, whenever this court uses the word cutoff marks, their meaning would depend upon the context. The words may refer to either the minimum marks to be secured in the qualifying examination or the entrance exam to be eligible for admission, or to the marks secured by the last candidate admitted in a particular category. So in the context, yes, ma'am. And what is minimum qualifying? They describe in paragraph 70. 1 second. Yes, ma'am.
I may rely on one judgment. Your lordship may kindly have it now. So this only one paragraph, paragraph 35.
Everybody is within the bracket of 30s.
21, Sachin Kumar case. I have paragraph 35. Large scale irregularity, including those which have a effect of denying equal access to be similarly circumstanced candidate, are suggestive of malign, which had eroded the credibility of the process. Next page. This is not a mere matter of administrative procedure, but as a principle of service jurisprudence, it finds embodiment in the constitutional duty by which public bodies have to act fairly and reasonably. A fair and reasonable process of selection to post subject to norms of equality of opportunity under Article 16(1) is a constitutional requirement. A fair and reasonable process is a fundamental requirement of Article 14 as well, where the recruitment of a public employment stands vitiated as a
These are the fundamental servers.
term obligatory. Only
The word servers, everybody knows about it in a service bill.
service.
Can be any other view as this.
And if your lordship will found, from the impugned order which is impugned in the writ petition, that is no reason ascribed, and they supplement the reasons by filing the affidavits. Therefore, this court, the Honorable Single Judge, after taking into consideration to the paragraph 8 of Mohinder Singh Gill's case, that has been dealt with in paragraph 46.
That what the authorities have taken.
What has been
The court, and that is where the bar
Yes.
cannot improve it.
improved. You cannot supplement or supplant.
Departure
Okay.
in a subsequent judge,
Okay.
where the MS Gill was departed to. And say this can't be a principle of absolute application. There are cases where the court may depart. That was an extreme case of Bihar, mass copying or the leakage of the papers. And there was a CBI inquiry that was conducted. And there what has happened, the same things that really came out.
Well,
And then the MS Gill was cited that you can't improve the case. The
well,
court said no, it all depends. In the rarest case,
yes.
you can definitely depart from MS Gill. You will not depart. So we have to see the MS Gill in that sense.
Justice Krishna here, writing for the Constitution Bench, paragraph 8. they have approved the judgment of 1952 Supreme Court. Paragraph.
Understood the
Yes.
meaning of all the words.
And most of the times it is difficult. Most of the time it is difficult.
We have very important judgment was the particular past scale. So I have to, in my diagram, I have to just put a meaning every word which is used. That in future it will come when I think like. Was wonderful way of writing.
And from coinage of words is very beautiful. Now, particularly in this judgment, your lordship will find no such high sounding words are there. Their lordship have used only, you cannot supplement or supplant. His lordship could have used some other.
Many times, we use it that it may supplement but cannot supplant.
If your lordship,
Can't have a whole idea.
if your lordship will come across the judgment passed by let Justice G.K. Mishra, let Chief Justice of this Honorable Court. The most simplest word ever used by any judge is by Justice G.K. Mishra. He has not used any complicated words. It can be understood by class 7 student.
What the Lord Bailey, when he was there, in the autobiography, he has said that the courts should use the words in the judgment so that the common people can be able to illustrate that what has gone or passes in the mind of a judge might be decided to should understand. He says, expression, the clarity of language in next to that leads to clarity of thoughts. If your thoughts are very clear, there is no language law.
Which is tagged with which
Which is like more.
Or like
has already provided some instruction.
Keeping this matter for order from the reopening, don't worry.
okay.
Don't treat it as a reserve. No, you are still wanting upon it. We may require certain clarifications from both of you.
Okay.
Yes, please.
Resolution of this.
All right. Well,
Into item, right? Same instruction. In case of both report.
Yes.
Item number 18, madam.
Yes.
Filing an affidavit, which is a file, it is a character affidavit, it is an enforcement affidavit to show the status of the criminal case. That is why I have been aware of this promotional benefit. The case will not be started.
What is what was the last order?
Last order by Lordford was to serve a copy and he has served the copy of that appeal. Delay was also confirmed.
The delay is condoned.
By the double application, everything. The only thing about the allegation they have made that because of the pendency of the criminal case.
Then it is better to admit that those not doing. We have to admit that we post for here. Because the ethics court wanted this matter to be decided on merit.
Yes.
So we definitely, we are fixing this matter. When? When?
Immediately. Because there is very small point.
Whatever it is.
18th, 18th.
Well, 18th. Yes.
Okay.
So you have filed it or you are going to file it?
I filed it. I will have the copy of land. I filed.
Yes.
Item number 3. Item number 3.
Item. Your Lordship, item number 3, my landed senior is not well. I prayed for an item.
Certification.
Right.
Or what is the good name?
Ashutosh Modi.
Ashutosh
Modi.
Modi. Ashutosh Modi. Appearing from that place, that is senior is. That is matter will listed 1 week out.
Yes. Item number 4.
My lord. My lord, I am making a small prayer, my lord. That your lordship kindly
A small but meaningful prayer.
meaningful prayer. My lord. This matter may be called along with all these 3 contempt. All these can be disposed of. If your lordship call it tomorrow.
Contempt cannot be tagged together, sir.
My lord, but all are similar.
It is against whatever.
Yes, sir.
Against because each act of contempt constitute a separate cause of action. How can you plug?
After the amendment, I think you.
Yes, exactly my prayer. I am just,
My lord.
I am just, my lord,
Further notification that the 1990
rule will apply.
rehabilitation assistance.
Yes, yes. My lord, I am just briefly submitting what has happened.
We have already taken cognizance.
Yes, yes, madam. So since they have already made the rule,
Date of death will be the,
date of death will be the relevant date.
that is the proviso.
That is provided that the new law, your lordship, they have made. It had again, kindly. So now, in all these cases, so my prayer is that, your lordship, since my lord have directed to apply the law which was existing on the date of death of the father of the petitioner, and that is exactly what the law has been amended in that line. So lordship may direct them to comply the order.
I may make one submission.
Contempt,
Only one, my lord.
you are in contempt.
My lord, only one submission. My lord.
This is the contempt appeal.
Yes, my lord.
So,
Only with respect to what direction and how we are not in contempt, my lords. That's what, only to that effect, my lords, if I make one
you are
submission.
not in contempt.
My lords, the
Then
paragraph,
we will enter into this aspect. And if we find that you are in contempt, then the provisions of the Contempt of Force Act will be activated.
there's only one submission because, my lords, in the impugned order, the direction was to dispose of in the terms of state of, in the judgment of state of Orissa versus Bindu.
The Bindusar.
Yes, my lord.
Yes.
Judgment is pending before that was
Pending, not state.
not state, my lord. That-
So,
In the meantime, you have brought out amendment.
so
So what is the effect of pendency of SLP?
then madam, we will invite, then I will deliver a judgment. I'd love to deliver a judgment on that. That we are pendency of a matter before the higher court without any order of stay. Whether it tantamounts to an automatic stay of the operation of the order, or it effaces the legal efficacy of the said order. We will, I will deliver a judgment on that. So we are passing, there are 3-4 Supreme Court judgments, which is in my knowledge.
My lord, what has happened here? Your lordship may kindly have a glance to page 9.
So you have subsequently made an amendments.
My lord,
You have brought you the judgment of the latest judgment of the Supreme Court.
but here what has happened? The honorable court disposed of it.
Disposed. Understand. So say that you are in contempt. There is no difficulty. Now it is a conscious or a technical contempt is the thing one has to understand. If it is a technical contempt, then the position is different. And if it is the other act of contempt, then why not?
My lord, here the contempt is the technical contempt. Why I would say, my lord? Because this case of Bindu Sagar Samantrai,
There the notice has been issued.
my lord,
No stay.
that is pending. I am not on that.
Whatever, no stay.
But that is a case of granting whether block grant teachers are to be entitled for appointment under rehabilitation scheme. That was the case. Here the petitioner is continuing under, he was given appointment on under rehabilitation scheme at in Group D post. He is claiming that my case should have been considered in terms of Group C post as per the old rule. However, this case was
What was his
disposed.
qualification?
That
What was his qualification?
Graduate, Your Lordship, graduate.
According to the eligibility qualification.
My lord, so far,
Whatever.
As per the old rules.
old rules, it was both.
There was no restriction, C or D. Later on, you have brought forward in 2016 amendment
Yes,
to 1990 rules
yes.
that it will be confined to
Group D. Group D.
So when have you considered his case?
But
When was the date of death?
the date of death was
Prior to 2016.
Yes, Your Lordship,
the
2002.
date was in 2002.
2002.
He was given appointment. My lord, under the 1990 rules, any appointment is subject to availability of the post. 5% of the post.
I understand.
Yes.
And
So-
he was there in the wait place.
Yes.
But these are the very regular features in any central government organizations.
But
There will be a list
Yes.
of the candidates
yes,
who are eligible for appointment on compassionate ground.
yes,
The moment that particular the vacancy arises, if would fit in those candidates in the on merit of seniority, they are appointed. So it is not that immediate the appointments have come. Though I am very much critical on this particular issue, but still I am not. These are the mechanism which is followed. So it so happened that after 5, 6 or 7 years, his term came
yes.
and he has been appointed.
He has been appointed.
Now question,
Sir.
then again I am saying, when his right to the appointment on compassionate ground accrued,
Yes.
then whatever is the right that accrued at that point of time
Yes.
is to be followed, or subsequently any amendment detrimental to their position or the interest to be followed.
My lord, even under the pre-amended rule, a person can be given appointment subject to availability of the post. Your lordship may we have not.
Have you found any review that you have not considered? I was party to that. Original order.
But that I'll have to verify.
I was party to that.
Yes, my lord's was particular.
So
I cannot.
So you have said so. You have said so that it comes within the purview of this Bindusar. That's your submission, I believe. Please read this out.
he cited that.
Okay.
They have not raised any objection. They consider.
Yes. There is no objection. Yes.
Have you filed any review?
We have not filed.
Then
any.
Sorry,
when you are,
I didn't notice this order, but
you are in
it's
contempt.
not to my brother who has brought to my notice. And you have really considered on 5/10/2023. Then what remains, sir?
Only that Bindu Sagar Samantrai case is pending before the Supreme Court.
Does it mean that the principles or the ratio of law is kept under suspended animation? No.
The answer
It
is no.
would still be a good law unless set aside by the Supreme Court or its operation gets staged. Omnibus.
I think that is East India 1961 or something.
Mere
That is referred to in one of the taxation matters.
Because it was being followed by the courts. That brought 1999 and 2002 amendments in the Code of Supersede. The Malumat Committee was constituted to overview the situations which was prevalent everywhere across the country in the courts. Then the amendment was brought under section 115 of the Code of Procedure and under Order 41, Rule 5 of the Code of Procedure, saying that mere filing of a revisional application or an appeal shall not tantamount to stay of the execution proceeding or the operation of the interim order.
Right.
That was necessitated because everybody was saying, appeal is filed before the High Court, stay my hand. Then the judgments that came, which says that Justice S.B. Sinha's judgment that it does not really face the ratio of the judgment, even if the matter is pending in the High Court, in absence of any express stay of the operation thereof is passed by the High Court.
I know my limitations in a content proceeding.
So this can't be done in this way. Then we'll have to consider him as and that is, he is a graduate person. Appropriate to his qualification.
With this qualification, and that is subject to the availability of the post. That is the provision under the even the pre-amended rule also.
I am saying that that post was available or not.
At that point of time,
when it becomes available.
Yes. So that I'll have
when it becomes available, Silas, it is not a case that it never becomes available. I don't think so.
I have filed an affidavit in the read that 100 posts were available under RTI. I have got it and filed an affidavit in the read.
Let me verify
that affidavit was there.
Verify and give us.
I'll
verify and give us. We will direct. Verify and give us on the new degrees.
That is Chauhan Missionary Mark in 2008. Inside. Division length forward
the learned Mr. Das, the learned and it's no damage. Stop. The dispute revolves around the appointment of the petitioner. Or the appellant, who is the petitioner?
the petitioner.
Appointment of the petitioner to the post of Group D on compassionate ground instead of Group C in terms of the rules / regulation prevalent at the time of the death of the employee. Full stop. Taking shelter under the judgment rendered by this court in the state of Odisha versus Bindusar Samantara Rai, which is WA 810 of 2021. Decided on 25/9/2023. Which is pending before the Supreme Court. The state government did not accede to the claim of the son. In course of the hearing, it transpires that there are several records in Group C which may have fallen after the death of the employee and the appointment of the writ petitioner, appointment of the petitioner to a substantive post to the substantive group D post. Mr. Das seeks accommodation to take an appropriate instruction whether any post, group C post, fell vacant after the death of the employee in harness. To stop. Let this matter to enable Mr. Das to take appropriate instruction. This is the matter. 1 week after vacation, we are keeping. Come with that, if there is, when he says 100 posts, verify that is there.
My 3 other 3 matters may come along with that numbers I have given. Similar matters were there.
Similar person died and siblings have applied.
No matter.
So
It is not.
each depends upon a different footing.
I got it. The Lordship would be kind enough to direct those matters to come tomorrow. It can be the same day.
Why on the last day?
Right. Item 18.
Yes,
Yes.
No.
Order dated 7/12/2023. Cast in documentation of unknown date of 6/23.
28/4/23.
7/12/23.
7.
December 23. So can you see page 9 of 10.
Says that the writ petition got disposed of
Right.
within 8 weeks. Then
Thereafter, petitioner communicated the order to the Tahsildar.
what is the matter which is the content is listed today? Where is the huh?
What's the name?
What is the number?
79.
File is the
Yes,
CO.
7990. Yes.
Is the content?
Yes.
Where is the content of it? Oh, this is the content.
Right.
They have not disposed of within 8 weeks?
No, ma'am.
No, we have disposed it of on 31/12/2024, madam. Passing out. Yes, madam. There were 2 other petitions also. Sorry, madam. So now, my lords, there is a status quo maintained in respect to the scheduled land. The encroacher of the above land has not been evicted because, my lord, there are other writ petitions also. My lord, if I hand over this.
No, status quo is maintained means there is an order passed by the court.
No, my lord, status quo with respect to the land is maintained by the Tahsildar, my lord.
What is the meaning of the word status quo in respect of the land to be maintained? I do not understand this. That means the remain who are there would remain there. That conveys the message to it.
My lords, if I may refer, my lords, in this matter, writ petition, opposite party number 4 also filed a writ petition before this honorable court. And there was an order whereby the writ petition, whereby the order, if I may read the order from the.
Any status quo, any impediment created.
In that order, my lord, it's mentioned that there shall be status quo maintained in respect of the said schedule land. Accordingly, considering both.
So that's, I was asking whether there is any order of the court. So you say that there is already an order of the court to maintain status quo. So you can't touch him. Is there only one encroacher or many encroachers?
As it seems, Three cases are filed here.
Yes, my lord.
WPC number 40842,
Four,
2023, 41154 of 2023. Two cases.
yes, my lord. In that, my lord, filed order dated 19/12/2023, it was directed that in the result,
And one of the
the
cases, interim order was passed.
yes, my lord.
Now, there are two ways, when it says that in respect of a land, that means it must be, it may be construed as the entire land which is under encroachment, or it may be construed the portion of the land occupied by that petitioner that they cannot touch. So in case of an ambiguity, if they have stayed their head till that is there, then in that event, how they can be protected? There is already a better put by an order. You can take your risk. Take appropriate step, whatever. What they say that we should be proceeding, but because of the it is not, we can't pass it. So in that event, they're not a. This is your order, please.
Item number 6.
Item number 6 will I need some time to do. I have not prepared the case, so after vacation also is.
Item number 7.
Please, your lordship. My lord, this matter arises of an issue. My lord, that there is a department called micro, small, and medium medium enterprises. In that department, my lord, the appellant was working as a industrial promotion officer, and subsequently, my lord, this department was bifurcated, and a group of officers, IPOs, being transferred, were meant to be transferred to the Department of Handloom, Textiles, and Handicraft Department. My lord, this new department, there were 92 posts to be transferred on the basis of a principle evolved by the government, my lord, which your lordship would kindly see at Annexure 4, that is at page 39, my lord. My lord, at page 39, your lordship would kindly see that this policy was that whoever will accept exercise option, they will be transferred. But if there is no, the number of persons to the post are not sufficient, then the principle of junior most employee to be transferred, my lord. Your lordship may kindly, the issue is very small. Your lordship may kindly see page 39. Kindly see, my lord.
Yes, we are at 39.
39.
Edition dated 28/9/2020.
Yes, my lord. Your lordship kindly see the option to be invited from the IPOs against the number of posts proposed to be transferred, except such and such IPO as per interim order dated such and such, arising out of such and such, on or before 9 October 20, report compliance to the MSME department. In the event of non-receipt of the required willingness, the services of the junior most officers in the cadre would be transferred to the Directorate of Handloom and CIO Bhubaneswar. That was the principle decided.
You exercised the option or you did not?
No, I did not.
So-
I did not exercise neither yes or no. But I did
So
not.
whatever, then in terms of 2, you will be transferred to a director of the HN.
Annexure 6, your lordship, kindly come
Yes.
at page 44, my lord. My lord, 92 industries promotion officers were transferred. First is, my lord, willingness and option exercised by IPO of the regional industry center or district industry center. That is, my lord, first A, my lord. Second is B, willingness option exercised by the IPO posted at such and such. C, my lord, list of IPO from junior most to senior working under the control of BI Odisha. This your lordship would kindly see. My name appears at item number 62, my lord. That is the first case, my lord. And 67, my lord, is the second OMW.
Page number.
Page 47, my lord.
Your client is Satyajit Behera.
No, my lord, Kamal Lochan Sahu, 62.
52 is a Satyajit Behera at page 47.
My lord, 62.
62.
Page 47.
47, serial number 62. That's rounded.
No, she's saying page 62.
No.
No, my lord, page 47.
Page 47, my lord.
Serial number 62. That is
I went there. 62 or 52?
62.
62, my lord.
62. Okay, serial number 62. I was looking at 52.
I'm sorry, my lord. I'm sorry.
Is the Kamal Lochan Sahu?
Yes, my lord. Then, my lord, what happened? There was no cadre rule or anything. We challenged the petitioner, my lord, challenged by way of writ application before this honorable court. My lord, while that was pending, the cadre rule of the newly formed cadre was framed, and the honorable court was pleased to pass an order that if your lordship kindly see that order, then it will be clear. Your lordship will decide the impugned order. Your lordship kindly see Annexure 1, the impugned order. The previous order has been quoted. Only the interpretation of that order is important, my lord. Page 26, my lord. I am shortening the my lord submissions. Page 26, my lord, of the impugned order. Your lordship kindly see paragraph 12. As stated above, the petitioners are here approached. Your lordship got it?
Yes.
Paragraph 12, my lord, wherein this court has disposed the same order by order dated 9/12/21 and said order dated such and such, it reads as follows. This matter is taken up through hybrid mode. Heard Mrs. S. Patnaik, Lord and Counsel for the petitioner, and Mr. H.M. Dhar, Lord and Additional Government Advocate for the state. The petitioners, by means of this writ petition, seeks to quash the resolution dated 28/2020, that is Annexure 3, under Annexure 2, and notification dated 28/9/2020, which I showed to your lordship, Annexure 4. Here it is Annexure 6, my lord. And then, my lord, the notification dated 29/10/20 that I showed to your lordships, that is Annexure 6 here in this AA at serial number 62, by declaring the action.
No, it has already been, there was already a formation of a CADA.
Yes, my lord. Yes, my lord, I am just coming. Mrs. S. Patnaik, Learned Counsel for the petitioners, contended that during pendency of this petition, cadre rule has already been framed, and therefore, if option is invited, the same should be done in accordance with the cadre rule. It is also indicated in the order number such and so, interim order, passed by this court in I number such and such, that since the petitioners are already in absence of any service condition to guide the petitioners in new establishment, the service conditions governing the petitioners at the time of relief shall continue till a service condition is introduced. As such, since service condition has been introduced, the same should be implemented. Mr. H.M. Dhar, Lord and Additional Government Advocate for the state, opposite parties has no objection to such proposition. My Lord, my submission to your Lordship is, we came to this Honorable Court because many juniors were there under me, my Lord. But they were not transferred, but I was transferred. That is the crux of the problem, my Lord. My Lord, those juniors list which they have become or they have implicated the opposite parties. What happened, my Lord? Those juniors, my Lord, in a separate writ application, challenge the resolution for the transfer of IPOs, my Lord. And this Honorable Court was pleased to issue order of status quo. So therefore, they were not transferred. Now, my Lord, in this impugned order, previous order, my Lord, the government agreed that new option will be asked to the IPOs, my Lord. So that is why the matter was disposed of, and I made a representation, but the government did not accept it. Your Lordship kindly come to paragraph 6, my Lord, of the impugned order, my Lord. Page 24, my Lord. The only question is, my Lord, my juniors are there and I have been transferred, which I would want to be repatriated to my parent department. That is the crux of the issue, my Lord.
You know, I understand. Your contention is that in view of that, the junior most in the cadre, they can be transferred. They are liable to be transferred in the event no option is exercised.
It will amount to
not. And according to you, you did not exercise the option. So,
yes,
according to the second category or the second conditions, the persons who are below or below the cadre, below in the serial number, they are liable to be transferred. Since they approach the court and the court has passed an order of status quo, so they cannot be transferred, but you have been transferred, ignoring that. So you are liable or you are entitled to be repatriated to your parent cadre or in a parent post of
now the cadre has
place of posting.
upgraded, my Lord.
Yes, this is what.
Yes, my Lord.
Suppose the status quo goes, then what happens?
Status quo now, they have withdrawn their writ application, my Lord.
So now there is no order.
There is no order. So therefore, now they have rejected.
So they are also transferred. Then they are also transferred.
They are, my Lord. They have not been transferred. They are retained in the post, my Lord.
Has been upgraded.
And those posts have been upgraded, my Lord.
And we have been
that is my sole issue, my Lord.
No, those have been what?
Upgraded.
The opposite parties?
The IPOs have been upgraded to assistant industries officer.
And
that post has been upgraded.
And you are?
I am an industries promotion officer. I was transferred to the new, that is a new cadre, my Lord. That is under handloom, textile and handicap cadre.
Those who came here got status quo and now withdrawn.
Madam, how can it be? How can you bring a stagnancy in there by virtue of a transfer? Transfer is not punitive. The transfer can stand in the way of their to forestall their promotional avenues.
If I may refer to the impugned order,
No, that is what he says, that the person who was junior to him, those who were not transferred, though you should, under that particular scheme, you'll have to transfer. Now they have been upgraded, they are given a promotion, they are getting a high scale of pay, whereas this gentleman who was senior to them is transferred to a particular organization or the other place where the stagnancy is there. There is nothing. He remained as such. His juniors have now become holding a higher position.
Yes.
Can it be done by way of a transfer? Tell me. What is? Whenever a difficult question is put, always an instruction. What is instruction? That's a pure question of law. Can it be done? Tell me. A person is born in a cadre. He has been transferred to another organization. And there is a stagnancy, there is no promotion. Whereas in the cadre, there is a avenue of promotion. Can you do it? I'm just asking.
They're given an option at the
Option for what?
for whether they want to choose which department minors.
So if they have not, that does not mean that it would go detrimental to their interest. That's a punitive punishment you will give. Option is what? Is a choice. One may not. And these juniors, they also did not opt. Had it been a case of the person having an exercising an option and then promoted, he has not exercised the option, I can understand. But his juniors, they also did not opt. Yet they have been promoted because they were retained in the same organization and he has been transferred. And the stagnancy is there.
And the upgraded post scale of pay varied.
Yeah, matter higher.
Higher, they are getting higher. The juniors are getting higher, and on a pretext of a transfer, he is getting. Is it a clear case of an injustice? How can it be done?
There is no
Option is exercised.
They have also not exercised the option.
That's what
They are benefited. Being junior, and he is deprived. Being a senior. No, madam, can't be. Repatriate him to his department and post him in the appropriate with all retrospective effect. We'll go to that extreme.
One chance will be given to the minors because to that if it has to take.
We can give you multiple chances, but we want a concrete answer. Tell us when you can give a concrete answer. We can give you. There is no difficulty. Tell us.
17, 18.
Whatever you can say, you have to. You will not be allowed to take a plea that you did not receive instruction. We are recording your undertaking. Yes.
You can come with a concrete answer.
The seminal point involved in the instant writ appeal is whether will lose all the avenues of promotion on transfer to a different department, whereas the juniors who stand on a same footing but retained in the parent department are extended the promotional benefits. The additional government advocate,
Standing council, additional standing council.
the additional standing council plays an accommodation to take instructions on the above score. Let this matter be listed on 18th.
19.
Why not 20th?
28.
Or 23rd? Fix on 19th.
Both the cases. Similar matter.
Both is man.
Notice has to go to private opposite party. Notice has to go to private opposite parties.
Repatriation, what opposite party?
They have
But
already.
they are not affected. We are not going to demote them. We are just going to extend them whatever they are entitled. That's all. We are not going to demote them. So they are not affected. Hmm. Huh. The counsel for the petitioner submits that instant writ petition contains a fatal defects which are incurable in nature and seeks leave to withdraw the same with liberty while afresh for the self reliefs on the same cause of action, on the identical cause of action. Such leave is granted. The writ petition is dismissed as withdrawn with liberty as prayed for.
Item number 10.
Petitioners, in this, so the sub-items are covered by your lordship's judgment passed in WPC 10982 of 2025, part on 75/2025.
What is that?
In absence of Chief Tribunal.
Okay. 10%.
Yes, yes. One corrected and one.
Both the matters?
Yes, sir.
Yes.
Item 11.
This is similar to item 10.
Yes. Have you seen? Yes. 12.
Item 12. Item number 12.
Then appears. Oh. Yes. For a day.
No. After long time.
For a day. Come tomorrow.
Item 13.
Item 13 is not the shortfall of the MCQ matter, but which have orders. I have corrected the 1 minute.
Yes. Have you seen that? Oh, sorry. No. Let her go. Go through the order. Yes, call.
Item number 14. Item number 1.
Submission matter for consideration.
Notice.
Section 11 petition for point.
Right. Item number 2.
Much obliged.
Then appears 3 weeks after vacation.
Item number 3.
Fresh matter. Fresh matter. Give a notice. 3 weeks. State is the. Are you? You want to fight counter? That is your opportunity. Yes. The issue notices. Mr. Das appears for the opposite partners or respondents. What is that? When waive service. So the petitioner is directed to serve the copy of the application upon Mr. Das. How soon? Tomorrow. In course of this week. The respondent is directed to file.
I've served on the AG. I don't need any subsequent service. I've served because
Now on Mr. Das.
Specifically, I'll do.
Course of this week. The respondent is directed to file the counter affidavit within 2 weeks after the reopening of this court following the long vacation. matter to be listed after 3 weeks, 3 weeks after.
Item number 4.
Page 10, most 10 is.
Just the item number.
Notice 3 weeks after.
Item number 5.
Fresh. 3 weeks after. Notice.
Item number 6.
Fresh.
Earlier, this court had appointed Honorable Justice N. Nageshwar. He has refused. He said that I cannot.
Then the notice has to be issued. The 3 weeks after.
For orders, item number 7.
My please, your lordships, I'm on VC. My lords, I'm on VC.
Yes.
Am I audible? Yes, my lords. My lords, the noting has come that the notices has been returned back to this court with an endorsement that addressee left.
Addressee not found.
Addressee left, my lords.
Addressee not?
Addressee left.
Acha, addressee left.
Yes, my lords.
So you'll have to give another address.
My lords, may I be allowed to submit, because my lords, the address that has been given in the petition is the same address in which the adjudication notice was served. Right, annexure.
So if he is avoiding, then you'll have to make a substituted service.
My lords, I'll take first.
By way of option or what? Substituted service if he is avoiding?
I'll take, my lords, I'll give it through mail if it is possible.
Then you'll have to take an application for that.
I'll take an application, my lords. I'll take it.
It is submitted by the counsel for the appellant that the postal article containing the copy of the instant application sent to the respondent returned with the postal remark within court left. Stop. He further submits that the respondent is still continuing his business activities from the address at the same address, and is therefore avoiding the service. First off, leave is granted to the petitioner to take out an application for substituted service within 1 week after the reopening of this court following the long vacation. List the matter immediately after such application is filed.
Item number 8.
I may be pardoned.
Lordship, I'm.
Senate is there. He was muted by the post.
Let me finish this. 8.
Item number 8.
So in item number 8, there is a noting that there is insufficient address where the addressee has left.
So you'll have to.
But on the contrary, Your Lordship, Annexure 6, they have replied to arbitration notice, which is the same address as it has been predicated in the arbitration
Then
application.
if they are avoiding, then the substituted service is the same order as the earlier one.
Item 9.
Insufficient address.
But this is a registered office address.
Then take out the alternative way, substituted service.
If they are in the war,
You'll have to take out 1 week after. Same order. 1 week after you make an application for substituted service, list the matter immediately thereafter. Yes, call the 2 item.
Item number 2.
Yes.
Item number 2
is a fresh application. Notices 3 weeks after vacation. Yes. Give a notice. Requisite within time, whatever. 12.
Pre-submission item number 10.
Lords, does that matter for appointment of substituted arbitrators? The Lordship completely judgments which I have made a notes of submission. Justice Rohington's and other 3 judgments, including one of Bombay High Court.
Who is for the other side?
Mr. Mahapatra.
Where is he?
He is there.
Yes, Your Lordship. I'm present here, Lordship.
Yes,
He's to hand over the copies. Do you have anyone in?
Now he is citing certain judgments in support of his contention. Now nobody is here, sir. Your counterpart must be here. Somebody.
Lordship, he's on.
You have to give a reply to this proposition of law.
Yes, Your Lordship. He's on legs on another court, Your Lordship. He's in the
What
seventh
can be
floor.
done?
So he's unable to
Divulge the
come.
name so that he will serve the copy.
Yes, Your Lordship. I've already asked him, but he's already on legs on in the seventh floor. So
Sir, the counsel for the petitioner is in dualdom. What to do?
I'll just give a reply, Your Lordship. I'll just go through the judgments. I'll just give a reply, Your Lordship. Short.
What give? Can you give a reply today, or you want to go through it? Tell us.
I just have to go through the judgments, Your Lordship. I think
So whom he will hand over? You don't know what judgment he is relying.
My colleagues know Mr. Partha Mukherjee very well.
Tell it to the council, name and all, whatever.
Should I send it to by WhatsApp or email to you?
That will be good. That will be good, sir.
Yes. The counsel for the petitioner hands over the short notes of submissions together with the judgment which he intend to rely upon in support of this the contentions raised in the instant writ petition. Stop. Let the same be taken on record. Let the same be taken on record. However, the counsel for the respondent submits. Now, submits that he may be given a copy of the same, so that he will respond to the points urged therein on the next date. Stop. The counsel for the petitioner is directed to serve the soft copy of the written notes of submissions upon the advocate appearing for the opposite parties in course of this week. This is the matter 1 week after vacation.
11. Obliged, Your Lordship. Item 11.
Maybe. The arbitration clause is at page 60.
Which for the other side, yes. Arbitration clause is
At page 60,
1(6) or 0.
clause 12.
Okay.
That here the arbitrator was to be appointed for this clause by the chairman and managing director of the opposite party. And the notice under section 21, Lord will find at page 108, annexure 22.
So this chairman and the managing director of the company has not appointed the arbitrator.
His unilateral appointment has been contrary to the law. Article 14, wherever public-private contracts are involved. So, my lord, at annexure 22, page 108, the section 21 notice was issued, and some impartial and independent names were referred. The names are there at page 111.
Yes.
At 111 are the proposed
5.
Then, my lord, at annexure 23, page 116 is their reply.
That is of 3rd of April 2023.
23 is the reply. Lord, the operative portion, my lord, would find on the next page at page 117. So, they do not deny the existence of the arbitration clause, but they say that the request is not in accordance with that clause, in the sense that the appointment was to be made by the chairman and managing director.
Correct.
Lord, thereafter, this application was filed on 22nd July 2024.
Have they filed counter?
Yes, my lord. They have two objections.
Yes.
The first objection is on the point of limitation.
And the second objection is on the ground that the present petitioner had initiated proceedings under the Insolvency and Bankruptcy Code, Section 9.
Against you?
The petitioner had initiated against the opposite party. So that was dismissed and an appeal is pending. So their contention is that a parallel proceeding cannot.
That IBC is a different, absolutely a different proceeding.
That has been clarified by
and if ultimately it is admitted,
yes.
And then the COC and then the RP, everything becomes correct.
So as far as this proceeding is concerned, this is impersonal.
And there is no, and the moratorium will not apply.
Moratorium will apply if that is admitted.
Correct. That is what I'm saying. Correct. So will not apply if it is not admitted.
Yes.
It is rejected.
Yes. So this is the sum and substance of they do not deny the arbitration. But as far as limitation is concerned, other objection on the ground of limitation. So in that regard, Lord, after the interplay and other judgments, the point to be examined is whether the application for arbitration is filed within the period of 3 years.
No, that is, it will start from the date of Section 21 notice.
Yes, please. So,
because the arbitral proceeding commences from the date of
21
notice.
So the application under 11.6 is within.
And why they say it's a barred by limitation?
They say on 2 scores.
Supplies were of what? Or the dispute.
Supplies were made.
And when they did not, they failed to pay the payment.
Yes,
make the payments. What was the date of supply?
The date of supply was 25th February 2020.
22nd February.
22nd February 2020.
And when Section 21 notice was given?
22nd March 2023.
More than 3 years.
Last supply was made when?
My lord, this is a supply by law. So the supply in dispute here is 22nd February 2020.
Okay, so after 3 years.
They contend that it is after 3 years, but may not be.
Was there any acknowledgement on their part in between?
My lord, there is.
Was there any acknowledgement?
My lord, actually, I will clarify this point. My lord, the supply was rejected on the ground that it did not meet the specified parameters. And the contract provides for testing with a third party government lab. So that testing happened in August, and a notice was issued in September 2020. So, my lord, as far as the cause of crystallization of cause of action for recovery, that happened only in September.
So according to you, this really is a mixed question of fact and law,
which is in the domain of the
arbitral tribunal to decide.
Yes.
So it cannot be thrown on the face of it.
Yes, that is. These are my limited contention.
My lord.
And where is the law that if the unilateral way of an arbitration is accepted, then is not in consonance with the Arbitration and Conciliation?
This is the 5 judges' judgment. Yours will find the conclusion.
Yes.
At 111 bottom.
No, I know. Yes.
111, the page 111, the bottom, the page number says.
Yes.
Conclusion P, para 169.
E. C.
A clause that, may I place please? A clause that allows.
No, I understand.
Yes. My lord will also take note of paragraph the other side. TRF and Eastman Perkins were upheld.
No, where is a discussion about the TRF and Perkins?
Yes, That's para 7. Para 8. In fact, it starts from para 6 where TRF is discussed. Until at page 7.
Just 1 minute. I'm just reaching. Don't worry. I think your case comes under the Perkins, not under TRF.
Yes, Perkins, para 8.
Not TRF.
Perkins.
Yes, now the three judge has accepted the principles of law laid down by Perkins.
My lords,
Now,
my objection is on the limitation, my lords.
the limitation, if the right to receive the money accrues from a happening of a certain events,
My lords.
then the limitation would run from the day, not from the date of a supply,
My lords,
because it is now postponed.
my lords, I refer to page
So it's a question of fact and law. Then it all depends upon the quality of the evidence that would be adduced before the fora. The Supreme Court in innumerable judgment has says that once it is a mixed question of fact and law and depends upon the quality of evidence, then it should be decided after the trial.
My lord,
It should not be nipped in the bud.
my lords, if I may refer to our rejection, my lords, the rejection of the supply.
Rejections on two scores. On two scores, you have rejected. One is the question of limitation, which appears is a debatable question, so it has to be proved. Second is you say that the procedure which is adopted in the arbitration clause, where your authority shall appoint the arbitrator, which Perkins, the Supreme Court has deprecated it, that a person who is himself an interested person after this radical amendment has come, Section 12, you can't.
My lord.
You can't. So it should be an impartial.
I may refer to only 3 documents from his application, my unit senior's application only. My lord, the is dated 22nd of February 2020.
True.
Our rejection, we say, hence the above rule is not acceptable to us and the same is rejected. You are requested to replace the above call immediately by the fresh one. After that, there have been many discussions, but this is the rejection from where the right.
What is the date? Accrues. What is the date of rejection?
25/2/2020. 25
So
February
if they have raised a dispute because they say that the contract provides that it will be sent for a testing, and after the testing report comes, then thereafter something is to be done. The testing was done, a report came in September. So it's a debatable one.
My submission is that the right to apply accrues from the rejection itself.
True, but the rejection, if it is certain pass, is also given in the contract. It is given.
Yes.
Where is the clauses of the
Rejection
contract?
clause is page 59.
Hey, give me the copy.
Lords will note page 58 tests.
No. In the contract.
Start from 57 at page 58, clause 3 is the test.
Yes.
Test will be kept.
$58.
Yes, ma'am.
Which clause?
Bottom clause 3. Test will be carried out by IRL India Limited laboratory or by third-party agencies deputed by IRL. Samples may be collected from IRL India Limited plant for test. You may deploy your representative to witness sampling of coal by IRL India and or for collection of sample. If your representative is not present at the time of collecting the sample collected by IRL India Limited representative will be sent for testing. The results of the test carried out at IRL India lab shall be treated for adjustments in payments. Next page. Cost of collecting samples and testing in lab shall be borne by IRL India Limited. If you are not satisfied with the test results, you may ask for referee sample to be tested in a government lab whose results shall be final and binding. You shall have to bear the cost of such test in the government lab and the same shall be deposited by you to IRL India Limited. Sample collection, sample preparation, analysis and testing at destination shall be done as per latest Indian standards IS 1350 latest. Now, my lord, clause 4 is the rejection. Coal received beyond acceptable.
No, that is what is there. I have seen already.
Yes. So the question is really whether the supply met the parameters. If it did not meet and this crystallized, my lord.
Yes.
Only at my lord will find page 78 is the test report. Annex 14, page 78. Is the test report, and my lords will find it's 14th August 2020.
Yes.
In fact, this report was not provided. The petitioner first came to know orally regarding the test results, and my lord will find at page 83 the first demand in fact made after knowledge of the test. Page 83, Annex 16. This is at it is September 25th, 2020.
Yes.
Lord, the bullets, the fourth bullet point, as informed by you that CSIR NML Jamshedpur National Metallurgical Lab has given a report of approximately 3400 kilocalories per kg gross calorific value of the referee sample sent on 14/8/2020. We request you to kindly release our payment stocks in 7 months when the GCB is above the guaranteed level of 3000 kilocalories per kg. So this was the first demand made after obtaining knowledge that the sample passed the test report.
Yes.
Now, then a legal notice was also issued, that is at page 89, Annex 19. This is on 12th November 2020. a demand was made and this was replied, my lord, by them at Annexure 20, page 98.
Page
98, 98, Annexure 20. Now, this was the denial. They denied on the ground that they had got the sample tested again unilaterally at another government lab. And that report is annexed to the counter affidavit.
So go and decide it.
My lord, my
Go and
submission,
decide it.
my lord, may have a glance at page 101, my lords.
Yes.
The order of the NCLT, para 3.
Yes.
The date of default is 23/3/2020, last sentence of that paragraph, my lords.
Which?
Page 101, my lord.
Yes. Where is 2020? Nothing.
Para 3, my lords.
Para 3.
The present petition was filed by operational creditor before
Yes.
last sentence.
Yes.
Annexure 21, my lords. Page 2 of 7, internal page.
No. One is the date of default, and another is a right accrued to claim.
My lord.
When the right fructifies, according to them, the moment the government testing lab suggested that the value or the quality of the goods are within that particular parameter, then they have said that my right to get back my money that really arises. Now you say unilaterally thereafter you send to another government lab and then the report came. That becomes a disputed question. So in that event, one has to interpret the contract in that sense. So far as the power of the court under Section 11 is concerned, we will simply go into the questions whether there is a live dispute liable to be decided by an arbitrator, and whether the arbitration clause is a genuine and legal clause.
May refer to just one judgment, my lord.
Yes, sure.
2000.
I'm talking about this SBP, keeping in mind the SBP and Patel Engineering in my mind.
2023 Supreme Court 2731.
Sure. Yes.
Para 1, my lords. This was a petition under Section 11(6) of the Arbitration and
Correct.
Conciliation Act. Then, my lord, the next page, para 9. The timeline has been given in the particular 16 through 2016, my lord, this my lord sees. Disputes arose between the parties. 22/9/2017, my lord. It is pertinent to state that between 2016 and 22/9/2017, the parties were constantly engaged in bilateral discussion, as specifically mandated by Article 21 of the contract.
Correct. So,
then, my lords, this at para 34, my lords, at page 2738. Para 34.
yes.
This refers to Article 137 of the Limitation Act and the last
There's
sentence of
the
the
general
paragraph.
clause. There's a residuary clause. Paragraph?
34.
Yes.
And the last sentence, my lord, of the paragraph.
Yes.
The right to apply has been interpreted to mean the right to apply first arises.
True.
After that, the time of limitation starts running, my lord.
Hmm.
And then they refer to the judgment in Bharat Sanchar Nigam Limited at para 47, my lords. Page 2743.
Yes.
In BSNL versus Nautil, this court undertook a comprehensive analysis of the relevant provisions and held that in cases where claims are expressly time barred, the court may refuse to make reference
No
under
doubt
Section
about
11.
it. Yes.
The last paragraph, my lord, the last paragraph of that page, the respondent, after a period of over 5 years, invoked the arbitration clause and requested for appointment of an independent arbitrator on 29/4/2020. It was also contended that the dispute of withholding the said amount would fall within the ambit of arbitrable disputes under the agreement. The appellant on 9/6/2020 replied that the request for appointment of an arbitrator could not be entertained since the case had already been closed and the arbitration was time barred. My lords, then I may refer to page 2745. The left hand side of that page, my lords, the last paragraph, last subparagraph. This court allowed the appeals filed by BSNL holding us under, applying the law to the facts of the present case. It is clear that this is a case where the claims are expressly time barred by over 5 years since Nautil did not take any action whatsoever after the rejection of its claim by 4/8/2014. The notice of arbitration was invoked on 29/4/2020. There is not even an averment either in notice of arbitration or petition filed or any of the intervening facts which may have occurred which would extend the period of limitation falling within section 5 to 20 of the Limitation Act unless there is a pleaded case specifically adverting to the applicable section and how it extends the limitation from the date on which the cause of action originally arose. There can be no basis to save the limitation. The present case is a case of deadwood, no substance.
Because it was absolutely clear because there was no correspondences, there was no such provisions. And
that has been referred in.
Everything is
para 51, my lords, of that page.
Yes.
The lower. The period of limitation for issuing notice of arbitration would not get extended by mere exchange of letters.
Absolutely. But there should be some cause of action. That is what I'm saying.
Or the sentence continues, my lord, or mere settlement discussions where a final bill is rejected by making the deductions or otherwise.
You say that you say that the material is substandard, rejected the claim, but the testing provision is activated the moment they raises a dispute. If they raise a dispute and the testing reports comes and says that it is within the standard parameters, then what? Then his right to claim the amount that immediately accrues.
In fact, that is the observation of the NCLT also at para 100, page 106. My lord, this judgment is before play. And the latest judgments restrict the interference at 11.6 stage to whether the application under 11.6 is within the limitation period. Lords will find this is 25 1 SCC.
Probably the judgment is rendered by the judges. This judgment, two of them are here.
Yes, they have also overruled their own judgment in Arifa's in clarified because after interplay, lot of
changes have
happened. So this note takes note of interplay. So my lord will find at page para 43, internal page 16. This is the law as it stands. Above they have discussed about the previous judgments. In para 43, therefore, while determining the issue of limitation in exercise of powers under section 11(6) of the 96 Act, the court must only conduct a limited inquiry.
Oh, that is what I say. If it's a mixed question of fact and law, then the court at the stage of 11(6)
Obliged.
This judgment of Arif Azim also takes into account this B and TG that my lords I was placing at para 80.
What?
Para 80.
Which judgment?
This judgment of Arif Azim. 2024 5 SCP 3-1.
This is the latest judgment of 2025, and that too by a 3-judge bench. It takes after the
same bench.
When there is a NN global dispute that hovers around from 3 judges to 5 judges to 7 judges. So when it came in the light, then what remained? Because that is what is also accepted. And the very interesting way of an argument which I have now experienced here is that everybody is hiding one judgment or another in his pocket. And the moment somebody takes a plea, then to counter that plea, the other side gives a judgment. The moment he gives a judgment, then the other side says, I have got also one in my kitty. Then I will give you that judgment. You have to make up a mind what they can cite and what you have to meet. One go you give. He gives one, you give another, then he will give another, continue. That's the only point you have said is a plea of limitation can be gone into section 11. He says if the plea of limitation is depending upon the quality of the evidence to be adduced, then it cannot be gone into under section 11. It should be left to the wisdom of the arbitral tribunal to decide. That's the only. So let me see the argument of both the sides. When right to claim accrues under the residuary article 137, or there is a specific article which is provided in the Limitation Act regarding the claim of money. And he's that's all, nothing more. Anything in your armory? Any other weapon in your armory?
My lord, my submission is that the petitioner went for the proceedings under the IBC. He slept over his claim to issue the notice under section 21 only after the order in the IBC.
Let us see. Let us see that if the person approaches the IBC, does it forecloses or waives his right contract or a statutory right which is also available to him. We have to decide that. We'll decide.
My lord. And the period spent before the IBC cannot be excluded under section 14 of the Limitation Act. The right to apply accrues from the first date when the rejection was there. From there, 3 years has to be seen, my lord.
So according to you, this section 14 protection cannot be extended to him.
My lords.
No difficulty.
There is a judgment to that effect also.
No difficulty. Who disputes?
It is not in
It should be a wrong forum. It's said to be a wrong forum.
issue here.
Can't be a wrong forum. So definitely they are not entitled to protection under section 14. No difficulty. Let us see whether it is a debatable one or it is an open and shut case as you have cited. Reserved.
Grateful.
Grateful.
Well, my lord, I am thinking because today I'm serving a copy to my non-friend.
The respondent files the counter affidavit today, and a copy whereof is served upon the learned advocate appearing for the petitioner in open court. In open court, so the petitioner prays for an opportunity to file rejoinder to the counter affidavit. The petitioner is permitted to file in 1 week after the reopening of this court following the long vacation. And list the matter accordingly. Next.
Annexure 1, running page 15, clause 25 is the arbitration clause.
This is a consortium agreement. More than one parties or what?
Yes. Both two parties. There are two parties.
Yes.
The petitioner and the appeal. And my lord,
what are you saying? This is the two parties.
Both were interested with regard to piling works for the fifth stream aluminum refinery at Daminjodi, Odisha, and related port facilities. And as per the clause 14 of the consortium.
What is this preliminary reply filed by the opposite party?
They have not disputed the arbitration clause, madam.
True.
He has rather taken clause 24 of the
Where is the arbitration clause? Show us.
Yes, clause 25, madam. Running page 15.
1-5.
Madam.
Yes.
Another element.
What is the dispute? What is the nature of the dispute?
They have not given our share.
Means?
Clause 14 of the consortium letter.
So they have not given your share.
Madam, that is the dispute. When we have raised the demand, they said that your demand is misconceived. Thereafter, we have issued notice under section 21, and they have not responded to that. So therefore, we have come before the lawsuit.
And what is the defense?
Claim, madam.
What is their defense?
Defense is that they have referred to clause 24, madam.
Yes, 24 is the arbitration clause.
24. 25 is that.
24. Which is not stipulated in the consortium shall be settled in the good faith by discussion.
Correct. We have asked for the.
So it says that this dispute is outside the purview of the arbitration clause.
Yes, they say that.
So.
But we have demanded the money, and they have said that no, your demand is misconceived one.
Okay. So let us hear that it is outside the purview of the arbitration clause.
Correct.
What is the meaning of the expression? All differences arising from an agreement. What does it mean?
Well, they said that our demand,
what is the law on the point?
50% of the profit which was generated from the total estimated cost, we are entitled to 50%. Then they dispute. The total project cost was 66 crores and some odd, and our case is that out of the total profit, 10% of the project cost, we are entitled to 5 crores and some odd. They are saying that the profit calculated at the rate of 10% of the contract price does not flow from any of the terms and conditions of the consortium agreement. But the consortium agreement says that we are entitled to, I am entitled to the share, and that is there is no specific term, but clause 14 your lordships. The parties to this agreement covenant
with each other that each of them shall be entitled to share received from NALCO according to work executed by them respectively without any reference to NALCO.
So it does not talk about any specific percentage, but it
Yes.
says that whatever the work has been done, executed by them respectively, the payment would be
But it
done.
is not their case that we are not entitled to any share. But when we raised the demand, they said that the entire claim is misconceived, thoroughly misconceived.
Because you did not work.
We have provided all the technical know-how as per the consortium agreement, and we have also demanded that, and they have replied to that, my lord.
Yes.
And whether we are entitled to 10% or 50% of the profit amount, that is a dispute, my lord, and that can be adjudicated by the arbitrator.
Yes.
My lord. As per clause 12 of the consortium agreement, the second party has been authorized to do everything, to raise bills and receive amount.
I have already read the entire agreement.
So taking advantage of this, he has received the entire amount and now says that you are not entitled to get anything.
Yes, here.
But I have filed my objection, my lords. Your lordship raised the question, my lords, whether any dispute arises out of the agreement, my lords. Because my lordship will see the claim, the nature of claim. What dispute essentially, my lords, the petitioner is raising, my lords. Your lordship will find from paragraph 8 of the application, my lords. Paragraph 8 says, my lords, the total contract value is 66 crores 72 lakhs 90,960. And where she calculates, whereas 10% to be the assumed profit. And his claim is 50% of that assumed profit now. And that comes to 3 crore 36 lakhs 3 crore 33 lakhs 64,548. This is the claim he works out in paragraph 8 below. Now coming to page 24, your lordship will find the 21 application, 21 notice below, page 21, a different calculation again. In page 21, your lordship will find page 24 below.
24.
24, my lord.
Yes.
24.
Yes.
Kindly see. it is submitted that we are informed of time to time. We have been acknowledging orally share in terms of clause 14 of the congestion agreement. You are indebted to us. And now he calculates this same amount, 66 crores contract value, into it comes to 10 crores, and he claims same analysis, 50% it comes to 5 crores. Here 3.33, here 5 crores. Now the question arises because this claiming 50% of the assumed profit doesn't arise from any of the conditions of congestion agreement. Conservative agreement, on the contrary, will not precisely speaks that itself comprises of two between the petitioner and the opposite party. They constitute the consortium lordship. And I am the leader of the consortium, and your lordship will find from the consortium agreement the entire financing execution associated. He is the associate, term the associate in the contract. He is not accounting any manner. He has the duty to,
his liability to execute the agreement is also, contract is also there.
He has the duty to participate in execution, but so far accountability before NALCO is concerned, I am accountable.
No, he has, because he can also make correspondences on behalf of you as a leader.
That's correct. That's
As a leader.
Yes.
So it's not that he is absolved of all the responsibilities.
Exactly.
And there is some sharing of the profit and loss as well.
Absolutely. Now,
So in that event,
this execution of this
work,
contract Millers, because he actually didn't cooperate. He didn't cooperate with us. And Millers, the contract law provides, in case of any non-cooperation of any of the parties Millers,
you can cancel it.
no, contract will continue, execution will continue. It is not
I have seen that it cannot be unilaterally dismissed.
correct.
It says that it cannot be unilaterally terminated.
Correct.
So you could have taken that you are not acting in terms of the agreement, and why not? We should cancel. If it is not, then you could have gone there.
I proceeded because the entire financing is me and entire execution is left to Millers. So I executed the contract, even if there is no participation, and I replied also. Your lordship will find, kindly see my lord.
Can this at the stage of 11 go? I am asking you.
So,
You may have a defense. You may have everything. Can it go at the stage of section 11?
At the stage of 11.
Only the scrutiny is peripheral.
Correct.
There is an existence of an arbitration clause. The dispute whether comes within the purview of the arbitration clause, and the dispute is of a live nature.
It's only
not a stale one or a.
So my precise objection here is 25 is there and 24 is there. There are two conditions in the agreement Millers.
Who can be appointed as an arbitrator?
That's if your lordship decide for going an appointment, then we'll suggest Millers. But only I refer.
We are going. I am going. Don't worry. You know the law better. You know you are engaged. That is there, but you know the law better.
So we are embarking upon clause 24 because
let us go. It is interpretation of a contract is within the realm of an arbitrator. The High Court cannot, or a court chief justice cannot do it. That's the last authority to interpret the contract. So why will go into this interpretation?
I leave it to the wisdom of your mind. I leave it to the.
I don't know anybody.
I think you're asking the panel
of lawyers.
Just give it to them. Use any name. Let them decide.
I suggest serial number 19.
Serial number 19 is already entrusted with some very onerous and very responsible task. Already a member of a committee.
Yes, so member committee.
Suggest. Don't put him under pressure.
Then may pay for Millers 17 or
both of you agree.
Serial number 17.
Correct. Is he not holding any post?
No. Yes, he's the chairman, RERA, I think.
But he is also being appointed the arbitrator, it is also doing.
Then why not 19 as suggested earlier? We were thinking that he is already interested, so 17 is also holding. So it's better that why not go for a 19? Why I reject 19? Your first choice.
I don't even object. Either 17 or 19.
Yes. This is the application under section 11 of the 11 within bracket 6 of the Arbitration and Conciliation Act 1996 at the behest of the petitioner for an arbitrator in terms of the arbitration agreement entered into between the parties on 25/9/2020. Stop. Undeniably, the parties to the proceedings entered into a consortium agreement on 25th September 2020 for participating into a tender floated by the what is this company? The NALCO. Floated by the NALCO.
Company. It's not NALCO.
It's not
NSA2.
by the NALCO for piling work for fifth stream alumina refinery at Damanjodi, Odisha, and post facilities as Vishakhapatnam, Andhra Pradesh. The said agreement contains an arbitration clause where the parties agree to resolve their disputes and differences arising amongst them regarding the said consortium agreement through an arbitral process to be conducted in accordance with the Arbitration and the Conciliation Act 1996. The clause 14 of the said agreement that the parties to the agreement shall be entitled to share the payments received from NALCO according to work executed by them respectively without any further reference to the said company. The dispute arose when the demand was raised by the petitioner in terms of the said consortium agreement dated 25th September 2020. Which was
They say clause 14.
I am not, which was denied by the opposite parties. The opposite parties took a defense that in absence of any stipulation in the said agreement on the percentage of shares, the claim is untenable. It is further contended that the dispute so raised in a notice under section 21 of the said act is outside the purview of the arbitration agreement, meaning thereby it does not come within the folds of clause 25 of the said agreement. Primarily on the aforesaid two counts, the of the prisoner was rejected, and the opposite party refused to nominate any arbitrator, nor concurs the name of the arbitrator suggested in the said notice. Was it suggested?
No, ma'am.
Oh, I did not concur with the proposal of the petitioner for nomination of the arbitrator. Before we proceed,
It was suggested.
That's nor concurs with the name of concurs with the arbitrator named therein.
Justice N.K. Modi.
Or whatever. Yes. Then what is that's true.
Before we proceed.
Before we proceed, or to decide whether the defense taken by the opposite parties is a justiciable defense in relation to section 11 of the said act, it would be apposite to quote clause 25 of the said act containing an arbitration clause.
I rely upon clause 24 by
I will come, don't worry, I will come. So, quote 25 from page 15. ঠিক আছে? On the manifest reading of the said clause, it is evidently clear that all disputes or the differences arising amongst the parties with regard to the said consortium agreement are agreed to be resolved through the private fora by appointing an arbitrator. What is sine qua non to invocation of Section 11 of the said act is that the dispute must fall within the folds of the arbitration agreement, as any dispute which is outside the peripheral of the said agreement, arbitration agreement, cannot ordinarily cannot be directed to be resolved through an arbitration. There are instances where they can come, no difficulty. Stop. The first and foremost duty of the court while appointing the arbitrator is to ascertain the nature of the dispute raised by either of the parties to the contract, and such disputes is amenable to be decided through an arbitral process. The conjoint reading of the several clauses contained in the said consortium agreement is indicative of the fact that the here to have agreed to participate in the tender process, as may be floated by the NALCO, and shall share the payment so received in accordance with the work executed by them. Clause 24 of the said agreement postulates that any matter which is not stipulated or covered under the said consortium agreement shall be settled in good faith upon meaningful discussions by the parties. Stop. The aforesaid clause is projected upfront by the opposite party to take a stand that the dispute so raised is not stipulated in the agreement and therefore cannot come within clause 25 of the said agreement. It is no longer it is beyond cavil of doubt that the arbitral tribunal is competent to interpret the various clauses of an agreement, and by virtue of section 16 of the said act may also rule its jurisdiction if raised by the parties. Whether the dispute so raised is within the four corners of the said agreement or beyond it can be decided by the arbitral tribunal, to which I do not find any fetter being put in any of the provisions contained under the said act. Whether the percentage which is conspicuously absent in the said agreement to be shared by the parties on the receivables from the NALCO would make the disputes outside the purview of the arbitral tribunal, when an earlier clause the parties have agreed to share such receivables from the said NALCO. It requires harmonization of both the different clauses of the said agreement in order to ascertain the nature of the dispute, whether it is it comes within the four corners thereof or beyond it. The limited scope under section 11 of the said Act is quite distinct, that the court must restrict its scrutiny on the validity of an agreement, the dispute having raised, which prima facie appears to have arisen between the parties in relation to the said agreement, and the claim is made strictly in terms of the said agreement, which does not require any roving inquiry or an evidence to be gone into. As we find that it involves a interpretation of the different clauses and the evidence to be led in order to gather the intention of the parties at the time of executing the contract, such dispute must be referred to the arbitral tribunal for its decision. Stop. However, we make it clear that it would be open to the arbitral tribunal to rule its own jurisdiction, irrespective of the fact that it is constituted in exercise of powers under section 11 of the said Act. Stop. We find that it is a fit case where the dispute raised by the petitioner should be adjudicated by an arbiter, by arbitration. Stop. We therefore appoint serial number 19 as a sole arbitrator who shall determine the dispute so raised by the petitioner. Now, to determine the dispute raised by the parties, mandate should I give of the within certain time? The mandate is given under the amended Act, and schedule of the remuneration as per the fourth schedule, or leave it to the parties to decide. You tell me.
Let it be as per the schedule.
The remuneration of the arbitrator shall be equally paid by the parties as per the fourth schedule, I believe.
Fourth schedule. Yes.
As for the arbitration.
Okay.
As for the fourth schedule. How much is your claim? 5.
At one place they say 3.3 crores, at another paragraph 5.3. There will be some
Is there any restrictions of claiming that the whole world belongs to me? The adjudication would be whether what it belongs to you. No difficulty. So they have claimed money.
Basis of claim remaining
There must be some
as per the fourth schedule
mistakes in calculating.
Exactly.
appended to the said Act. Where is a clause, a section limiting that particular period within which the arbitral award, the award has to be?
29 capital.
29 capital.
This all seen after the judgment of Justice Nariman in Ashok Builders or Ashoka Traders. What is?
29 capital A.
The arbitrator shall make efforts to adhere the time limit set forth in section 29 capital A of the said Act. Disposed of. Yes, call the
Item note 14.
Yeah, pleasure. Being open time to file rejoinder to the counter flow against.
time to file rejoinder is extended by a week after the reopening of this court following the long vacation. This is the matter at a date.
4th July. Item 15.
15, Madam, I am appealing for the respondent one.
Sir. Who is for the petitioner? Yes. Whether the counter is filed?
No. No.
He has an opportunity to file counter.
No counter has been filed.
So, after hearing the respective parties, the respondent or opposite party, whatever, is directed to file counter affidavit within 1 week after the reopening of this court following the long vacation. You want to file rejoinder?
No, madam. I will orally.
The rejoinder, if any, may be filed within 1 week from the date of the service of the counter affidavit. This is the matter after 3 weeks. 3 weeks after. Call the
Item 16.
Please.
When appearing for the opposition for 2 minutes and paying some time to file counter meeting.
File counter 1 week. Rejoinder if you like 1 week thereafter. Better to appear 3 weeks after. Yes.
Item 17.
Please, madam. The arbitration agreement is at annexure 1.
Anything file counter?
Yeah, file counter.
Yeah, file counter. So arbitration agreement is at?
Annexure 1. The need copy is at flag B.
Huh?
Flag B, we have given a need copy of annexure 1.
Flag B.
Original one was not.
Not. Where is the flag B? Flag A and flag C I got. Hold on. Give me the scanning done.
In the PDF version, it would be at page 282. The Lordship is checking the PDF version.
This is a raising contract.
It's a raising contract. It's a raising contract, and the important clauses would be on page 1 itself. Just towards the bottom. Owner wishes to engage. So we are the agent here, and the owner is the private. We were appointed as the agent in terms of Rule 8A of the Metalliferous Range Regulation, 1961. For production of bauxite.
No, where is a clause for agreement? Clause for this arbitration clause.
Clause 12.
12.
Which is at page 24. Clause 12. That if any dispute and
amicably mutual settlement, and then thereafter
there are named arbitrators.
Correct.
One of them has died, and the other one is our employee. So in terms of section 12,
you can't.
So that's how
12(5). Now, what is the dispute which is raised?
Now,
nature of the dispute, I just wanted to know.
One important clause here would be that the agreement was valid till renewal or revival period or till complete exhaustion of the detected mineral deposit. That is at clause number
Whichever is earlier.
whichever is earlier.
So,
Which includes the renewed or revived.
and the revived period or till the completion, I do not know what this English is.
Complete exhaustion
of the detected mineral deposit.
Whichever is earlier. Now here in the dispute actually began in 2022 when they tried to block our renewal process. We were trying to get this mine renewed. At that time, they filed suits against us. And
You are an agent, they are the principal.
They are the principal.
Okay.
We were trying to get it revived and renewed. And thereafter, from 2022 onwards, this dispute began. So our section 21 notice, my lords, is at page number 86, annexure 8.
Page
86.
Yes.
Now, the relevant paragraphs of that notice, my lords,
Very difficult.
would be paragraph 5 at page 88. Paragraph 5, 6, and 7.
What is this paragraph 5?
That it has
That you, the noticee, has initiated several various litigations and are creating hurdles in connivance with the, what is this? Earth and Environment Consultants. So as to halt the entire process initiated by
our representatives
before the state.
For lease renewals.
And
the requisite permission required for mining operations with regard to the agreement in question.
okay. And
Then that your action of stalling the lease renewal process is delaying our contractual obligation arising out of the above mentioned agreement and other agreement as well. That the said action of yours is putting great loss due to non-cooperation.
and then what do you claimed? What you claimed?
And for non-payment of higher machinery charges. These are our claims.
And show us from the agreement that these are one of the conditions of the agreement.
My lord. That my lord may kindly see page 19 of the agreement.
19.
Page 19 is the, it may not be a very legible copy, but the clauses are just.
Oh, I can't read.
Given the neat copy at flag B. Neat copy. Sorry.
Black copy is the worst copy which.
In fact, I'm so sorry for that. We have given a neat Xerox copy towards the end.
It should have been done in the same format. Otherwise, that creates a.
Neat Xerox copy also.
No, it's not there. No, even I have seen. That's a very.
Type.
Lordship, I appear for the respondent in this matter.
Yes.
In that regard, I have minor submissions to make. What they have been stating for a very long time that this.
I think they have not completed the arguments, sir.
Lordship, I was under the impression that they stopped so.
No.
I'll apprise once they are done.
Yes.
We have also got a clean Xerox copy. Today we are giving. We have given a typed copy.
Yes.
We also given a clean Xerox copy.
No, I can read to some extent. Yes.
I'm so sorry for that, Miller. The neat clean Xerox copy will be parallel copy of.
Oh, yes. Which one you are referring?
Now, let me kindly see page 19 of the.
Yes.
Clause would be validity I just showed, clause 3, which would be at page number 3 of that document. Scope of work, my lord, we see. Scope of work, systematic and scientific operation of the mines, excavation, raising of bauxite so and so, of marketable quality and management of associated rejects 2 years so and so. rate is fixed, then next page, that will be clause number 4. Agent shall work as mining agent of the
managing agent of the
owner for the purpose of execution of the mining operation work under the mining lease, and shall safeguard the interests of the owner for smooth running of the mines, and the agent do maintain good relations with the mining department, forest, or his government departments, and shall keep the owner absolutely free from all types of liabilities and problems. Then 5, in all matters connected with labor and staff under this agreement, the agent shall be the employer as defined in various relevant acts, rules.
Where is a clause which says that you can approach the government for renewal or extension of the mining lease on their behalf?
Now that specifically, my lord, is not.
So now the question, because your allegation is they are putting a spanner to your initiative for renewal and or extension of the period.
So for that reason, I had shown clause 3. Clause 3, which I read earlier.
Yes. So so it says till the ultimate end of the mining lease.
May I just place that again?
Validity.
Till the ultimate end of the mining lease,
Correct.
which includes renewed and or revival period.
Correct. Now, please, that means the period of the mining lease is the important thing. Inclusive, when the include word is used in the agreement, means they expanded the really horizon of that particular restricted meaning to something else. So they say that if the initial period of the mining lease was, say, for 10 years.
That was roughly around
Then
2011.
Whatever, 10 years. Then if it is spelt like this, then after 10 years, you don't have right. When the include word is there, means if after 10 years it is renewed or it is again, what is another revive, then in that event you will continue. This will not come to an end. So you wanted to take a decision or a initiative for renewal.
May I just explain? This was executed in 2010. The period left was 1 year. So from 2011, this process of renewal began. And from 11 till 22, because my lord knows that mining renewals take a lot of time. So from 11 onwards, we kept on trying getting all these approvals. Now, that's the reason why I was...
And you continued the mining operation as well?
Yes, for 1 year. For 1 year.
Thereafter?
Thereafter, the renewal process started. And things were fine till 2022. So here the words here would be ultimate end of the mining lease, which includes renewed and or revival period, or till a complete exhaustion of the...
Whichever is earlier.
Whichever is earlier. So obviously, the deposits have not gone. Now, renewed period is there. Renewal period, we are entitled to that. That litigation, all those cases are going on. So at this, and my lord, there's one more thing. We have come with those judgments. We have given a short note which says that this contains the arbitration clause. But suppose there are ancillary, this is the main agreement. Suppose there are ancillary agreements that can also be taken note of by the honorable arbitrator.
No difficulty. Who says so? That he cannot. But that is what the ancillary agreement show, the intention of the parties and relevant for the purpose of interpreting any of the clauses of the agreement.
So, those agreements also we have given here in this case itself. That the Lordship may kindly see the agreement between the petitioner and that would be at Annexure 3, page 47, which it's a tripartite agreement. Between the opposite party and Gayatri Maini and the petitioner. And your lordship's query regarding renewal is at page 50. This I hope this is a clean copy. Page 50.
Is a tripartite agreement.
My lords. So we stand of Gayatri Maini, and page 50, this renewal thing is there. My lord, the exact question is answered at page 50. And whereas ML period would expire on 25/8/11,
Yes.
efforts have to be made and steps have to be taken for renewal of the aforesaid mining lease in accordance with 24 of the MC rules 1960. And it requires a lot of pursuit. And on the next page, there's a reference to regulation 8A of the Metalliferous Lines, which is the statutory agent which we have been appointed. And in fact, if you lordship, if I can show, there's a
Very difficult.
Image.
Very difficult.
In fact,
And the loss in the last clause 7 is also.
In fact, that's the reason, my lords, for your lordship's convenience, we have prepared a short note, which is
Clause 7 is also there.
My lords.
How far we can enter into a contract? That's the whole thing.
There is one judgment also which says that if there is one agreement and other.
I have anything which is ancillary to or incidental or flowing from the parent agreement containing an arbitration clause, then in that event, there is no difficulty in taking note of those, because I find there is a reference of a raising agreement which has already been entered into in this particular tripartite agreement. So there is no difficulty in this regard.
But what falls from your lordship is correct, that clause 7 would stand in the way, but then there are other agreements to which we have made payment.
Where are those?
No, those, my lord, somehow have not come on record.
You'll have to bring on record. If you say that if it is there, then it has to be brought on record. Something prima facie, I must find that there is a dispute.
Well, it's prima facie, my lord, if I can show, first would be that this raising contract, the validity is still exhaustion.
No.
Or at least still renewal, my lord.
But the renewal has not happened.
The process
but that is what I'm saying. The renewal has not happened.
In fact, for your lordship's convenience, at flag C, we have given a short note. Can I just show that?
But in absence of any contract, in these further agreements which you have entered into, can we? I do not want to go. This arbitral tribunal who will go. Only thing is that all these things on the face of it, let him then decide.
Well, that's it. That's precisely what the Honorable Supreme Court post 2015. There are a series of judgments. We have listed it for convenience in a 2-page note. You can see that.
But where do I found? Because you have raised an issue that your primary dispute is that the owner is not cooperating. Rather, he is creating all kind of obstacles in getting the lease renewed. That's your primary concern.
Then, my lords, there is one more judgment where they now even bind non-signatories.
Oh, Sukanya Holding and then
This Cox and Kings.
Cox and King, that's a group of companies theory has been doubted by the court.
My lords. So now the non-signatories can be brought into arbitration.
It is doubted. It's because the Sukanya Holding, the Cox and King, before that I think there was another judgment. The Cox and King has taken note of that judgment.
We have got that judgment. Cox and Kings came about in 2024, analyzing everything.
There was an earlier judgment where the group of, this is what is the theory of group of companies.
Bureau Felgura is the
Group of companies theory that was sought to be brought.
So, now,
so say whether the Indian legal parlance can we bring it is doubted.
Basically,
and the earlier there was one judgment. I'm just forgetting the name.
Lordship, I believe it's Bureau Felgura where the mother agreement is to be taken into consideration.
I just forgot the name of that earlier judgment.
Lordship, chloro control possibly.
Fluoro control, all
fluoro control.
At page 27, they have listed out all the judgments there. Now, if you lordship would see what I'm basically trying to make out here is that we are at this point, once there is an agreement, the court has to leave it for the arbitrator to decide. This is what Cox and Kings.
No difficulty.
Even non-signatories can be made.
Oh, there is no difficulty. Only thing is a prima facie satisfaction.
My lords. Here, the raising contract has the arbitration clause.
But the nature of the dispute which you are now raising is whether that raises a doubt.
Obviously, this would have expenses during that period. That is one of the issues. Then this renewal process has happened. So suppose
but the lease has not been renewed as yet. Had it been renewed, your right gets really.
In fact, those cases are all going on.
Rectified by that.
Those cases are all going on. So now in this process, now what has happened is they are blocking. There's a civil suit where they are trying to revoke the power of attorney. In that civil suit, we can't have our claims adjudicated. Of course, we have intervened there, and by Order 1, Rule 10, we have been made parties there. But that suit cannot adjudicate these claims of us. So
no, definitely not.
So somewhere this dispute has to go.
No,
and that is
but we have to other agreements. Where are those agreements?
The tripartite agreement I showed.
That's there. I have seen.
That has a reference contract.
No difficulty.
So here, what I'm trying to build.
But again, what was that contract?
Tripartite agreement was that we step into the shoes of Gayatri Maini and we take on the process of renewal.
That is what is there, but the things are different. If you look at that agreement, it does not really talk about. There is a reference, recital contains, but the clauses.
Here, if you lordship would allow me, may I show that one judgment of the Honorable Supreme Court in Amit Lal. That's there in my short note. You just show that. And their counter basically is that they are raising territorial jurisdiction, saying that Orissa doesn't have jurisdiction. That's one of the points which they say, which according to me, because we have lost once in Madras. We went to the Madras High Court. They said that on territorial jurisdiction, we were turned down. Here also, they are raising the issue of territorial jurisdiction.
So, and they are not saying that which court has a territorial jurisdiction.
No. Flag C, it's a 2-page note.
Correct. I have seen.
So, their counter relevant paras I have quoted there. And what would be important, my lord, 11.6a, my lord, knows that at this stage, it's minimal intervention.
Absolutely.
And then Goki Tech, recent judgment of the Supreme Court, where they say that all that has to be seen is prima facie existence of arbitration agreement.
Correct.
And para 20 of Goki Tech, we have quoted at page 3.
The paragraph 20 also quoted the frivolity of in litigation too is an aspect which the referral court should decide at this stage of section.
As the arbitrator is equally, if not more competent to adjudicate.
Yes, the obvious is within the realm.
And Cox and Kings I have given, of course, because of it's a 5-judge bench judgment. Now governing after this amendment to 11(6)(a), Cox and Kings comes into the picture, and non-signatories now, if non-signatories can be made parties, then at least we are parties who have an arbitration clause.
Oh, that's not a point which germane here.
And it's trying to persuade your lordship from that point of view. That if non-signatories can be brought in, then
So non-referable dispute will also be brought in.
No.
So
Absolutely non-referable or dead wood, your lordship can obviously turn down the request. But this is not a case where it's a case of absolute dead wood. This may be a case where there are some disputes arising out of the raising contract and some from the ancillary contracts. Here, my lords, Amit Lalchand would come into the picture. If your lordship would see, that's the judgment which is to our case, my lords. That would be at page number of that note, page number 14.
40.
14. And the relevant paragraph begins at page number 684 on the left hand side. That's page 20. May I just place para 1, the background facts. Application under section 8 was dismissed on the ground that the agreements between the parties are not interconnected with the principal agreement dated so and then super is taken. And then in paragraph 12, the points for consideration have been listed out. (12.1) 4 agreements have been listed, and in here, like the case here, only one agreement had the arbitration. Most important paragraphs will be paragraphs 25 and 26.
Yes. There's a concept of a parent agreement, yes, and then all the agreements flowing therefrom.
Deeply great. So a combination of this Cox and Kings, which says that non-signatories can be a part, can be parties, and this new regime post 2015, where they say that 11 court there should be minimal intervention. Those judgments, may I just quickly run through? Goki Tech I showed, that's the latest one. Then Cox and Kings, the 5 judgments also refers to that. And other judgment also, Chris Finney, if your lordship wants, I can show that. All judgments now are saying that at 11th stage, there should be minimal intervention. You leave it to the honorable arbitrator to take a
No,
call.
no doubt. I have also dictated that. All the prima facie, the view, this, may I say, the bird eye view, not a eagle eyes view.
Their basic objection, my lords, to the section 21 notice is that since you have intervened in the civil suit, you get your disputes adjudicated there. That's
Anyhow,
their basic.
I have some administrative meeting today, so let me have some. How many are left? So these are all the hearing matters subsequently?
These are all contested.
Okay.
Some of them they may agree, but
Let us take after vacation. Anybody who is appearing after that?
Well, it's item number 19 and 20. Counter has not yet been filed, your lordships.
Who is appearing in 19 and 20?
My lord, I'm appearing, your lordship.
Yes?
Okay, I am appearing. I have already filed.
You are for the Union of India?
Yes.
So you want a counter?
Yes, I have filed.
Oh, you have already filed?
Yeah, on 3 for 2025.
I am on this email.
So he has already filed a counter, 19.
I am
My 19 and 20, I have my item number 19 and 20. I have not received the counter yet.
So he says that he will.
Yes, your lordship.
You will serve.
Item 18, my lord. I am on this email. On behalf of Mr. Mahapatra, he is out of Qatar. Let it come after vacation.
But lordship, my item 18 we have filed the counter. That's why we reflected this. 19.
Sir, we were keeping all the matters after vacation. Only thing is that any matter which can be of any importance before this side of the vacation. Otherwise, everything will go after
That
vacation.
much importance, my lord.
Obliged.
Yes.
The division will matter, morning matter.
Tomorrow. I thought it will not take much time, but two arguments took consume more time. Anyhow.
Lordship, would item 17 continue after vacation?
Yes, it will continue after this.
Obliged, Lordship.